All right. Good afternoon to everyone. My name is Wouter Lambrecht. I'm the president in your case, and I have the pleasure of being assisted today by Mr. Dennis Koolaard, appointed arbitrator for the appellant, Mr. Olivier Tom, and Mr. Mark Vedovatti, party appointed arbitrator for FIFA. Before we go into the actual way of how this procedure will go, I just maybe quickly ask the counsels for both parties to present themselves.
Good afternoon, Honorable Tribunal. My name is Nkrumah, and my co-counsel is Vincent Fach. We represent Stockholm University, and we are currently representing Mr. Atom of Appellant. Thank you.
Okay, thank you. Both of you will be developing oral pleadings, or
Honorable Tribunal, I will be presenting the procedure, and then my co-counsel will present the merits of the current dispute.
All right, thank you. For Respondent.
Good afternoon, esteemed panelists. My name is Linda Muro, and I'm here with my co-counsel, Sydnie Hornback. We represent the Respondent FIFA. I will be talking about the procedural issue, and my co-counsel will be talking about the merits.
Okay, thank you very much. Nice to meet everyone, and I hope that we'll have a fruitful session today. Before going into the actual merits of the case, maybe very quickly some technical remarks. As you know, this meeting is being recorded, and as this is a virtual hearing, I would actually ask everyone to mute themselves when not speaking. And as in any other arbitration procedure in front of the counsel, of course, interruptions are not allowed when the other counsel is pleading. Just some basic remarks. I guess that is clear for everyone. Yes, okay.
Yes, thank you.
Then as to the procedure that we're facing today, this is of course a very sensitive matter that we're facing. And before going into the merits, I actually want to ask the counsels for the parties whether they are happy with the way the procedure has been conducted up until today.
Honorable Tribunal, as of today, we are happy, and we would like to highlight that we've already come to an agreement in terms of the timings, and that each party will present for 10 minutes, and then 30 seconds for the rebuttal and rebuttal, so in total 1 minute. However, when it comes to the actual structure, we have agreed the appellant will start with the procedure. However, there are disagreements for the merit part, as respondents suggest the appellant should go first. Our proposal is that the burden of proof is on FIFA to actually show that appellant was in breach. And thus, we request the tribunal to ask the respondent to start first. And furthermore, this is a matter of equal treatment. Thank you.
Okay, thank you. All noted. Respondent, do you have any observations or any comments in that respect?
Just that we agree to the time allocation as well as the rebuttal. And the only dispute that we have is the allocation of which party will proceed first for the merit issue.
So do I understand correctly that you have agreed on 10 minutes oral pleadings on procedure and then 10 minutes on merits, or?
Yes, Honorable Tribunal.
Okay, all right. And then that there's a discussion or a disagreement on who should go first on the merits, no, correct?
Yes,
correct.
All right. Well, let me consult with my co-arbitrators in the breakout room, and we'll take a decision on that, and then we'll get back to you after that.
Thank you.
All right, councils, thank you for waiting. We've reached an anonymous decision whereby we reject the request by appellants. We see no reason to deviate from standard practice whereby appellant goes first. We're also make appellant aware that you have received the legal briefs of respondent, namely the skeleton, and that therefore you can anticipate the arguments that will be raised by respondent in terms of the merits. Having said that, we shall continue to the actual content of this hearing. I will start with the procedural remarks. Namely, we've taken note that you have challenged two of the arbitrators in this case, so would like to hear from you on that specific point. Thank you. Appellant, and then respondent after that.
Thank you very much, Honorable Tribunal. Good afternoon, Honorable Tribunal. In the matter of Atom versus FIFA, my co-counsel, Mr. Vincent Fach, and I represent the appellant, Mr. Atom. We are here today because our client has been accused of a very serious crime, which not only is to be judged by a biased arbitral tribunal, but it is also relying on inadmissible evidence. On this backdrop, Counsel for Appellant submits that this CAS tribunal has jurisdiction to hear the present appeal, and that this appeal was lodged within the 21 days limit as requested by the FIFA statute, specifically Article 58(1). Counsel for Appellant will focus on two main procedural issues. Firstly, on the challenges to Mr. Vax and Mrs. Omaima, and secondly, on the admissibility of evidence. Moving on to the first procedural issue, which is the challenges, we submit that these challenges must be upheld. As per Article 33 of the CAS Code and Article 180C of the Swiss Pillar, an arbitrator needs to be independent and impartial throughout the whole arbitral proceedings. However, both the parties failed to meet the standard of impartiality required. Moreover, this challenge were lodged within the 7 days time limit requested by Article 34. As soon as the grounds for challenge was known, we are presenting them. Counsel for Appellant would like to focus on the first challenge, which is that to Mr. Vax. We submit that this challenge is admissible and substantiated. Challenge is admissible because appellant fulfilled his duty of curiosity, and substantiated because Mr. Vax's LinkedIn comment gave rise to doubts as to his impartiality. Focus on the first submission, which is that of admissibility. Opposing counsel might argue that appellant should have been fulfilled his duty of curiosity once he knew about the appointment of Mr. Vax. However, we submit that we could not have been made aware of the LinkedIn comments no earlier than the 4th of March 2022, when this comment was actually read by a legal member of the appellant. We kindly ask the tribunal to consider the case of the Swiss Federal Tribunal of December 2020, with case reference 4A_318/2020, which can be found in AL1. And in this case, the Swiss Federal Tribunal held that a party is not requested to have a systematic and thorough research of all the sources, even if they're readily available online. And furthermore, this is more pressing when there's an ever-evolving nature and number of social networks. If we apply the same principle, LinkedIn is a social network, and our appellant was not requested to go and look for the social networks. Now, focus on the second submission, which is that of the substance. Mr. Vax's LinkedIn comment also meets the threshold required, as it has been stated in Article 34, but also in the Swiss Federal Tribunal case I mentioned. In fact, it has been held that the contested circumstances give rise to the appearance of doubt. Now, Honorable Tribunal, I can ask you to go to the page 27 and specifically Exhibit 7. Here, we can see that Mr. Vax not only commented under his wife's comment advocating for vaccine as an effective tool against vaccination, against pandemic. He advocated over 10 lines and called people that are against vaccinations as a danger to public health, that they endanger the lives of others, and that they're egoistic people that only think about themselves. For someone that is to be judging an issue such as bribery, which has connotations such as being self-seeking and egoistic, a tribunal that holds such strong views is very worrying. Furthermore, this is the only comment of his up to now. Therefore, the matter of vaccination is clearly dear to his heart. How can an arbitrator that holds such strong views be able to judge with sound judgment and maintain impartiality. Focusing now on the challenge to Mrs. Omaima, we submit that this challenge is admissible and substantiated. She must either provide us with information or recuse herself from the proceedings. Article 179.
So, sorry to interrupt you there for a second. Actually, I forgot to mention at this beginning, of course. I mean, myself and also my co-arbitrators, we will and we may, we could interrupt you at any moment in time to ask you specific questions in terms of the argument that you are developing. And I actually do have a question in regards to the argument that you're developing on the post by Mr. Vax on the vaccine, his position on the vaccine approach. My question is, how does this affect his independence with regards to the matter that we are considering today, which has nothing to do with vaccines?
Honorable Tribunal, we stated that both arbitrators do not meet the standards of impartiality. And furthermore, this comment is warranted because he's discussing egoism. Our client has been accused of serious crimes such as bribery, which often has connotations of egoism and the people that always are self-seeking. And thus, for an individual that holds such views, and Mr. Atom is publicly known to be against vaccination. Therefore, for an arbitrator to hold such views against unvaccinated people, it is very dangerous and worrying, and there's clear issues as to his bias. And I would like to reiterate that we mentioned the Sunyan case, where it has clearly been stated that an arbitrator is able to express their opinions online. However, we need to look at the circumstances and the choice of words, which in the Sunyan case gave clear appearance of bias. And in our case as well, there's a clear appearance of bias because a third party can, from an objective point of view, can see that the choice of words will give these issues, presiding arbitrator.
Okay, thank you. Please continue.
Honorable Tribunal, on the issue of Mrs. Omaima, we submit that Article 179C of the Swiss Pillar imposes upon her a duty to disclose any information that might give rise to justified doubt as to her appointment. We would like to highlight that she provided us at the last minute that she had been appointed by FIFA, that she had been acted as an arbitrator in proceedings involving FIFA. Furthermore, we do not have any information in regards to how this appointment occurred and how the outcome was. We have requested to solve this issue, but as of now, she has not provided any information. And thus, there are issues in regards to her being in clear avoidance of her obligation. Now, focusing on the second procedural issue at hand, which is the evidence, Counsel for Appellant will focus firstly on the anonymous witness statement. We state that admitting anonymous witness statement infringes upon appellant's rights to be heard under Article 6.1 of the ECHR and also Article 29 of the Swiss Constitution. This is because it infringes upon Swiss public procedural rights. We kindly ask the tribunal to actually consider the cases of Poveda versus Wouter, which has case number 1920 and it's from 2009, and also the cases of Contador, which is from 2011 and it has case number 2384 and 2386, as well as the Karim versus FIFA case from 2019 with case number 6388. Here it has been stated that anonymous written statement can be admitted as long as it does not infringe upon Swiss public issue and that there has been provided that it meets strict conditions and it's not just mere support to further evidence. Honorable Tribunal, the anonymous witness statement is one of the key evidences at hand. Furthermore, there was no cross-examination provided to appellant. And lastly, respondent witness statement alleges threat. However, this has not been substantiated as of now. And thus, this evidence is inadmissible. If alternatively it was to provide it, we ask the tribunal to give us further audiovisual tools such as it was stated in the contador cases. We are in 2012, and it has been shown that it is possible to have various proceedings online. Now, looking at the last submission, which is that of the Telegram messages.
Sorry to interrupt you once again, Counsel. What was the last point that you were raising, you were requesting exactly?
If a tribunal was to consider the witness statement, we request that we are provided with 5 alternative cross-examination tools.
Okay, thank you. Please continue.
For the Telegram messages, we submit that this also infringes upon the right to be heard, because we asked the tribunal to consider the Football Club Metalis case from 2013 with case number 3297, and the Guillermo Lazo from 2014, case number 3467, where first of all, in the Football Club Metalis, it has been stated that unlawfully obtained evidence can be admitted as long as it does not infringe upon Swiss procedural public matters. Here, the right to be heard, which entails the right to a fair trial, is enriched in the Swiss constitution. And thus, if we admit this without being able to actually cross-examine the hacker, because there's no information as to his identity or where this information was extracted, this procedural issue will be infringed. And for the Guillermo case, the chain of custody has not been met, Honorable Tribunal, because compared to the Guillermo case, there, the witness were the ones that were actually carrying the extracted information. However, here, we do not have any information as to the identity of the hacker, and thus, it cannot be admitted. To conclude, we submit that this CAS tribunal has jurisdiction to hear the present appeal, that the arbitrators must be, the challenges to the arbitrators must be upheld, and that the evidence inadmissible. Thank you very much.
Thank you, Counsel. I don't know if my co-arbitrators have any specific questions at this moment in time. If not, I would give the floor to counsels for FIFA.
Mr. President, sorry to interrupt. I do have a question for counsel, for appellant, if I may. Counsel, you mentioned Article 29 of the Swiss Constitution and then Article 6 of the European Convention on Human Rights. And then you mentioned the concept of Swiss public policy. Is your argument that Article 29 of the Swiss Constitution, Article 6 of the European Convention on Human Rights falls under the concept of Swiss public policy? This is your position?
Honorable Tribunal, we submit that it's a matter of Swiss procedural public policy.
Okay, but so your position is that Article 29 and Article 6 falls under the concept of Swiss procedural public policy?
Honorable Tribunal, often the ECHR is not directly binding on the CAS Tribunal. However, we have highlighted this in this case because we wanted to further restate that the right to be heard is a fundamental matter of Swiss public policy. And this is enriched in Article 29. So it's a matter of procedure. And that's why we kindly ask the tribunal to consider the case of Football Metalis, where it has been stated that the unlawful obtained evidence can be admitted as long as it does not infringe upon this. So in this instance, the use of the ECHR for us is as a guidance for this tribunal to be guided. However, the procedural matter is relevant here because the seat is currently in Switzerland. So we have to consider such provisions on our tribunal.
Thank you, Counsel. I don't have any further question at this stage. Thank you.
Okay. Does my co-arbitrator, Dennis Koolaard, have any questions or not at this moment in time?
No, not for the time being. Thank you.
I do maybe have one more question for you, Counsel. In terms of the exhibit 8, so the no, so not the exhibit 8, sorry, the exhibit 6, the screenshots. Are you saying that it has been illegally obtained and has been hacked, or are you also alleging that those messages were never exchanged in the first place? That this is
Honorable Tribunal, we are not arguing that he has been hacked or he has been. The case file states that this information was provided by hacker. So our issue is not that it's been unlawful obtained, but our contention is that the unlawful obtainment of this evidence infringes upon the right to be heard, and which is infringed.
But you do not challenge the accuracy of the messages.
Honorable Tribunal, could you please repeat?
You do not challenge the veracity and the accuracy of the messages and the exhibits.
There is a clear uncertainty, which has been represented by both parties. So that's why we stated that the chain of custody has not been met. And that's why we asked the tribunal to consider the Guillermo case. If tribunal would like to have more confirmation, at page 8 of the procedure number 1, section 22 asks, what is the date of the supposed telephone conversation between Mr. Atom and Mr. Lenders? It is unclear. And section 23 asks, beside exhibit 5, was any other information extracted from Mr. Atom's phone? What was the chain of custody followed to protect this exhibit? And it stated it is unclear if the telegram conversation was extracted from Mr. Atom's phone. So that's the answer.
Okay, thank you, counsel, for responding. We would like to hear from you.
Thank you. Good afternoon, esteemed panelists. My name is Linda Muro, and I am here with my co-counsel, Sydnie Hornback, on behalf of the respondent, FIFA. Let's not call a penalty kick on a clean tackle. In football, a penalty kick is given when an offensive player is fouled within a penalty box. Here, FIFA made a clean tackle, and it was outside the penalty box. Therefore, Mr. Adams should not be given a free kick. Before this panel today, we will discuss two major issues. One issue regarding the procedure of this arbitration, and one on the merits of Mr. Adams' involvement, which led to the recent selection of the Big Land World Cup. Turning now to the procedural issue, I will be discussing three sub-issues. First, the jurisdiction, then the challenges against Mr. Vax and Ms. Umema, and lastly, the evidence justifiably relied upon. Now, as my opposing counsel stated, the CAS has jurisdiction to hear Mr. Adams' appeal. However, the challenges against Mr. Vax and Ms. Umema should not be upheld. The challenge against Mr. Vax should not be upheld because his stance on vaccinations does not give rise to justifiable doubts as to his independence and impartiality. Opposing counsel stated that Mr. Vax's comment indicates a lack of impartiality. However, his desires for a safer world and his personal opinions toward the unvaccinated do not take away from his ability to be impartial in a proceeding focused on sports and bribery. Arbitrators are arbitrators for a reason. They have demonstrated their ability to be impartial, and their judgment should be trusted, even if they have differing personal opinions about things, because they are just that, personal opinions. And Mr. Vax is able to keep that separate from his professional decisions as an arbitrator. Mr. Vax does not have a history of these types of allegations. There have been no prior complaints about him on the record. There are no issues on him being able to do his job impartially. So while Mr. Adam might be the public face for anti-vaxxers, this is not an issue about vaccination. And since there is no indication that Mr. Vax has ever used anything other than his professional judgment in deciding cases, we cannot assume that here. Because if we apply that logic here, then we must apply that logic to every single arbitrator and investigate whether any of their opinions outside of their professional life collide with that of the people bringing cases before them. Moreover, the challenge against Ms. Umema should not be upheld either. As to her previous arbitration service, The record states that Ms. Umema has served as an arbitrator 4 times, but not that she was appointed by FIFA 4 times. Footnote 5 of Code 3.1.3 in the IBA guidelines explicitly states that if the sports arbitrator pool is small, there is no need for disclosure since the pool is small, and therefore some arbitrators may be used more often than others, as Ms. Umema has been. So even though Ms. Umema waited until 5 days before the proceeding to disclose it, and it might not have been ideal, the facts remain the same. She was not required to do so. Could she have disclosed it sooner? Perhaps, but she did not violate any codes by waiting because she didn't actually have a responsibility obligating her to disclose it. And even though opposing counsel stated that Ms. Umema has not disclosed certain information in relation to this, again, she is also not required to do so. And also, it should be acknowledged that the CAS and parties that come before the CAS want experienced arbitrators. Being an experienced arbitrator is not a negative thing. On the contrary, it is a positive thing because it means they know what they're doing. Furthermore, the fact that a former member of FIFA's legal team joined her firm also does not give rise to justifiable doubts as to her independence and impartiality, because it does not inherently mean that Ms. Umema will show favoritism. It is an attorney who just joined, not an attorney she has been working with for a long time. And even if this new attorney had joined her firm sooner, Ms. Umema is a professional. And page 9 of the procedural order states that this new attorney works primarily with Ms. Umema's partner, not so much with Ms. Umema herself. But even if they worked together, attorneys understand the concept of conflict of interest and take measurements to ensure they are working ethically. And we must look at the bigger picture. They work in a law firm together, not a private company that is trying to make profits off of the results in this case. These are lawyers we're referring to. Now, as to the evidence, the CAS should admit the evidence relied upon in support of the FIFA appeal decision. To begin, the CAS should, I thought I heard a question. To begin, the CAS should admit the whistleblower statement from the Harlan proceeding found in Exhibit 4 on page 9 of the record, because the fact that the whistleblower remained anonymous was reasonable given the circumstances and says nothing about his credibility. In our situation, the whistleblower was afraid that if he was identified, he would be subject to reprisals and intimidation. Again, this is reasonable given what is at stake here. Opposing counsel stated that witness anonymity is not justified, but it is. Although opposing counsel might not see the threat to our whistleblower's safety, anyone familiar with the World Cup would. This is the World Cup we are talking about, the event that brings countries, cultures, and people together or tears them apart. Now, this whistleblower is accusing an official who voted on the location of the World Cup. This is big. Our whistleblower very justifiably fears negative repercussions if his identity is known. Opposing counsel also asked for cross-examination tools if this statement is admitted, but FIFA considered that there was no need for such cross-examination, given that the whistleblower had already been examined by a judge in the context of the Harlan criminal proceedings. And it seemed that the whistleblower fears that the football fans may want to retaliate against him. Now, inclusively, the CAS should admit the telegram of the text messages between Mr. Adam, the appellant, and Mr. Lenders, as seen in Exhibit 5, because of the public's interest in holding this official accountable. For example, in Manchester City versus UEFA, a very recent case from 2020, the panel found that the interest in discouraging people from engaging in hacking by excluding evidence is outweighed by the public's interest in holding the other party accountable for its wrongdoing. In our case, Mr. Lenders messaged Mr. Adam and asked him if he had made his mind up about the elections. Mr. Adam replied, saying that after thinking about it and after all they had done for them, the least they could do is vote for them. Mr. Lenders agreed and stated that they could not draw back now. So the public's interest in knowing whether their vote was based on their time in Bigland is essential. Therefore, the public's interest in knowing the truth outweighs the method the truth was uncovered, much like the Manchester City case. So although opposing counsel raises the issue of it invading Mr. Adams' privacy, this is a case involving the World Cup. So again, there is great public interest in finding out whether the voting was based on bribery, therefore making the telegram messages immensely important and as such justifiable. So it is important to fight the corruption here and put a stop to officials who are bribed. The integrity of this sport is on the line, and we must continue to fight for it. So for the foregoing reasons, the challenges against Mr. Vax and Ms. Umeima should not be upheld, and the CAS should admit the evidence justifiably relied upon in support of the FIFA appeal decision. The world is watching, and we must preserve the integrity of everything this sport stands for. Thank you.
Thank you, counsel. I would maybe ask counsel for both parties to take the FIFA ethics code, because I believe there might be some questions in relation to that specific regulation. Co-arbitrators, do you have any questions at this moment in time?
Yes, I do have a question, two in fact.
Okay.
The first one about the challenge of Mr. Vax. You are familiar with the CAS code saying that the challenge must be erased within 7 days. Now, I did note that the LinkedIn post came into your knowledge only 3 days before today. So in that sense, it is within the time limit. But I also noted that Mr. Vax provided his CV when he was appointed in this case a long time ago. And he disclosed on his CV that he is the president of an NGO, Association for Eradicating Diseases, from which you may have inferred or investigated further that he had specific views, either professionally or personally, about vaccinations. How does that impact on the challenge? I would ask first the appellant to respond, and then maybe the respondent.
Honorable Tribunal, the CV mentioned eradication of diseases. This wording is very generic and is not what has given us the grant for challenge. We are contesting the wording that is found in the LinkedIn, which is the one that gives appearance to bias. Honorable Tribunal, as we've already enunciated, the strong wording and the strong stance of Mr. Vax, and accentuated by the fact that this is his only comment as of now, and he's not very active in LinkedIn, shows how he has such convictions against unvaccinated people. Thank you.
Thank you. And how does that relate to the duty of curiosity?
Honorable Tribunal, as we've already discussed, the duty of curiosity arises in terms of a party going and looking for information related to an arbitrator that might give rise to legitimate doubts. The doubt here has arisen, as Honorable Tribunal has mentioned, only 3 days ago when our appellant legal team read this comment. And that's when the challenge has been brought. And that's when the duty of curiosity was fulfilled, Honorable Tribunal.
Thank you. Respondents.
Thank you. Esteemed panelists, as opposing counsel very clearly stated, it is the only comment he has posted as of now. We don't deny that this comment was made online, but it does not rise to such a level as to challenge Mr. Vax's impartiality. We are before the CAS on issues of sports and bribery, not vaccinations. The mere fact that he has a differing personal opinion on vaccinations.
Sorry, Ms. Muro, if I may interrupt.
Yeah.
That addresses more the substance of whether there's a reason for a challenge. I'm looking more into the procedural aspect as to the timing of the challenge.
Thank you. As to the timing of the challenge, I don't raise any objections to it. My issue in relation to this is of the substance of it.
Thank you very much.
Okay. Thank you, Mr. Koolaard. Continue to your next question.
The second question relates to jurisdiction, because I noted the respondent does not object to the jurisdiction of CAS, but I must say I have some doubts myself, which is kind of an unusual situation, but I would like to take you through the FIFA Code of Ethics. If you could take that in front of you, please, and have a look at Article 82, paragraph 1, first of all. Give you a quick second to take it in front of you. So it says, with the exception of Article 81, decisions taken by the adjudicatory chamber are final, subject to appeals lodged with CAS. Now here we have a decision of the adjudicatory chamber, then there was an appeal to the appeals tribunal from FIFA, and then to CAS. So this is the third instance. Whereas I read from 82, in principle, there should be the decision of the adjudicatory chamber and then directly CAS. So no competence for the appeals body of FIFA. But there is an exception to the rule that refers to Article 81, paragraph 1. And that subsequently refers to Article 29. And that, if I summarize it, relates to match fixing. So my question to you is twofold. First, a procedural aspect, because the respondent already acknowledged that CAS has jurisdiction. So are we bound by that, even if we as a tribunal would find, hey, we clearly have no jurisdiction because you engaged into the merits of the dispute without objecting to jurisdiction? Are we blocked from deciding that we don't have jurisdiction? Or can we decide on jurisdiction ex officio, even if the respondent did not object? That's the first question. And the second question is whether...
Mr. Koolaard, maybe let's let the parties the time to answer the question, because it's quite a large question before we go on to the second question. Unless counsels for both parties need a minute to prepare an answer to that question. In that case, maybe Mr. Koolaard can continue mentioning or asking the second question while you prepare an answer for the first question. Counsels?
I would like to hear from respondent first, if I may.
Thank you for raising that point, esteemed panelists. If you were to find that there is no jurisdiction, we would, of course, very respectfully accept that, as we are okay with the prior decision. However, we did not raise an objection to the jurisdiction in this case, because Code 82 does state that it is subject to appeals lodged with the CAS, and pursuant to CAS Code R47, since Mr. Adam did exhaust all internal legal remedies, and since we were not so concerned with the jurisdiction of it, but more so with the challenge against the arbitrators and the challenge against the evidence, we didn't focus so much on the jurisdiction, because we are very confident that with the other issues we spoke about.
Okay, thank you very much. Appellant?
Honorable Tribunal, I request you to look at Article R55 of the CAS Code, where there is clearly the competence principle. So this panel has the power to rule on its jurisdiction, and therefore you can decide ex officio. Thank you.
Thank you very much. And I've to the president, my second question was related to the substance of whether there is jurisdiction or not. But I think the parties have already addressed that, so there's no more questions from my side.
Thank you, Mr. Koolaard. Mr. Vedovatti, do you have any questions for counsels?
Yes, Mr. President, I do have two questions for counsel for respondent. So my first questions, you mentioned at some point, I think it was where you was discussing independence and impartiality of Mr. Vax. You said that he demonstrated to be able to judge or something like that. You say something similar, unless I'm mistaken. So my question is your position that impartiality and independence does not need to be analyzed on a case-by-case basis, that you can rely on previous cases?
Thank you for your question, esteemed panelist. You are correct. I did state that he has demonstrated his ability because he has demonstrated his ability to remain on CAS's list of arbitrators. He should be trusted and he is reliable. But the point I was trying to make is that, in essence, there are certain issues that may arise that will cause us to question their impartiality. However, this specific quote unquote issue does not rise to the level of questioning his impartiality, because it was simply based on one LinkedIn comment that had nothing to do with the substance of why we are before the CAS today.
Thank you. A follow-up question, but which is the test that needs to be applied? Because you're speaking about a threshold, but which is the test? Is there a subjective test or is it something else?
At this very moment, I have been under the impression that it is a subjective test. There has been nothing that opposing counsel has raised or brought forth indicating that there is a specific code or a specific rule or regulation of an objective test. So currently we are looking at it subjectively.
Thank you. Mr. President, I have another question. I don't know if you have the time. Otherwise, yes. I can ask. Yes? Okay, thank you. So my question is again for Counsel for Respondents. You mentioned the IBA rules, and you said something like that this arbitration IBA rules don't really apply in sports arbitration, and that Madame Umaima, she didn't have the obligation to disclose any potential issues of impartiality and independence because we are in sports arbitration. So my understanding is that your position is that sports arbitration is somehow something different. So my question is your position that in sports arbitration, where we are talking about independence and impartiality, a lower standard applies? This is your position?
Esteemed panelist, I would respectfully have to disagree with you. That's not what I stated earlier. Earlier when I spoke about it, I was referring to footnote 5 of code 3.1.3 in the IBA guidelines, which states that if the sports arbitrator's pool is small, there is no need for disclosure of previous arbitration service since the pool is small. So the guidelines definitely apply here in sports. But what I was trying to relate is that there was no need on Ms. Umaima's behalf to disclose that she was an arbitrator for previous time to this party, because in this case, the arbitrator pool is small. And because of that, that guideline falls into our case today. So my position was that even though Ms. Umaima waited until 5 days before the proceeding to disclose that she had previously been an arbitrator 4 times, to which FIFA had been a party to.
Sir. Apologies to interrupt you there, Counsel. I think you are expanding a bit on what was asked to you by Mr. Vedovatti. Mr. Vedovatti, are you happy with the answer that you received? Or
I am, Mr. President. Thank you. I don't have any further questions. Thank you.
For both counsels, I also have a question with regards to the evidence, whether or not it is admissible. I would actually like to refer both parties or both counsels to Article 44.2 of the FIFA Ethics Code. I'll give you a couple of seconds to get that document in front of you. Please confirm when you have it.
Yes, I have it.
Respondent.
I don't have it in front of me yet. I'm so sorry. I need one more minute. Esteemed panelist, it seems that I cannot get it in front of me. However, you may proceed and I will do my best to answer your question.
Let me try to share it on screen then.
Thank you.
Is it on screen now for everyone? Yes, maybe take 20 seconds to quickly read Article 44.1 and Article 44.2, and then I will post my question. I do assume as counsel for FIFA you are familiar with this provision, so please hurry up. Counsel, are you ready? Counsel for FIFA, are we ready?
Yes.
Okay. No, can you please expand on how the exhibit of the anonymous witness statement, which I understood has been marshaled in and FIFA has not had a direct contact with this anonymous witness statement, how it actually lives up to and complies with the Article 44.2, where it says that such evidence is acceptable under certain conditions, namely if the parties as well as legal representatives had the opportunity to pose questions to the person concerned, at least in writing. Can you please expand on this, please, in terms of the eligibility or illegibility of the witness statement?
Please rephrase your question.
Sorry, no, I'm looking at your own rule book where you, according to the FIFA Ethics Code, Article 44.2, FIFA has set certain criteria whereby evidence can be used or will be, from what I understand, considered either illegible or admissible or inadmissible if it complies with Article 44.2, which states that the parties as well as the legal representatives had the opportunity to pose questions to the person concerned, at least in writing. What is your interpretation of this article and how does it impact the eligibility of the witness statement in the case at hand?
Thank you for your question. As far as the record reflects, opposing counsel did not try to ask any questions to our witness via writing. There was no indication that they tried to and weren't able to. So it's our understanding that they never chose to. But however, FIFA did consider that there was no need for cross-examination because the whistleblower had already been examined by a judge in the context of the Harlan criminal proceedings. And because of that, we find it to be admissible, even though the witness remains anonymous, because they were already seen by a judge in the Harlan criminal proceedings. And so the whistleblower is credible, and it is also justifiable that they remain anonymous for the purposes of this CAS proceeding, as I stated earlier, because of their fear of reprisals, intimidation, and negative repercussions because of the severity of the situation we are dealing with.
Correctly, that your point is that you consider that Article 44.2 does not apply because counsel for appellant has not asked to pose questions to respond to the witness, no? Correctly? Okay. Counsel for appellant, please.
Honorable Tribunal, Mr. Atom was not indicted in the criminal proceedings in Harlan. There is a clear due process breach, and I would like to highlight to this tribunal that Harlan is not part of the ECHR, and therefore, to further strengthen our argument, we must be provided with the rights to actually cross-examine this evidence. Thank you.
Thank you. I just had some problems to unmute my button there. Okay, I think so. We've heard your pleadings on procedural remarks. I propose that we continue, like I understand that you have an agreement, or that at least we have decided that appellant should go first in terms of the merits, and then I understand inter alia the sanctions. So please, counsel for appellant.
Honorable Tribunal, are we progressing with rebuttal?
Sorry, come again.
Are we progressing with the rebuttal now?
I think we will do that after after we hear from you on the other outstanding points. Okay.
Thank you very much.
Honorable members of the tribunal, my name is Vincent Fach, as previously introduced by my co-counsel, and I would now like to address the merits on behalf of Mr. Atten. In this regard, I would like to make two submissions. First, that there was no breach of Article 27, Section 1 of the FIFA Code of Ethics, and second, that even if such breach occurred, the sanctions imposed upon Mr. Atten of a ban of 15 years and a fine of 50,000 Swiss francs is grossly disproportionate and must be reduced accordingly. Regarding the first submission, I would like to point out to the tribunal that under Article 27, 3 requirements must be met cumulatively and with the standard of comfortable satisfaction. First, that a person is bound by the FIFA Code of Ethics. Second, that it received any undue or other that it received any pecuniary or other undue advantages. And lastly, that it received those advantages in turn for granting a business opportunity to someone else on behalf of FIFA or outside of FIFA. And as stated, these requirements must be met under the standard of comfortable satisfaction, which is higher than the standard of balancing of probabilities that we might know from civil law proceedings. But it doesn't stop there. I would like to draw the tribunal's attention to the decision of Moon Yoon Jung, a CAS award from 2017, with the case number 5086, in which Mr. Jung, a Korean football official, was being disciplined under the FIFA Code of Ethics. And here the CAS panel held that the more serious the allegation is, the higher the threshold should be for a tribunal to be comfortably satisfied that the breach occurred. In light of this, and in light of the circumstances of the case, I submit that while we do not dispute that Mr. Atten is bound by the FIFA Code of Ethics, neither did he receive any advantages, nor was there a quid pro quo. Regarding the advantages, I understand from the opposing party's skeleton argument that 3 alleged advantages will be raised. And I would like to start with the trip Mr. Atten and Mr. Lenders undertook to Bigland, because the opposing party might try to portray this as a luxurious vacation. However, members of the tribunal, I would like to draw your attention to the Procedural Order 1, to Annex 1, and here it is question 3. And the question is, what was the agenda of Mr. Atten's trip to Bigland? And the answer is, Mr. Atten and Mr. Lenders were guided by Mr. Kaiser in visits to Bigland's touristic points, stadiums, and training facilities of the local football teams. This goes to show that when they went to Bigland, it should be a fact-finding trip because they wanted to make up their mind about the upcoming World Cup election for the World Cup 2026. Therefore, it does not constitute an advantage under Article 27, Section 1 of the FIFA Code of Ethics. Further, the opposing counsel might argue that Mr. Atten received gifts on behalf of Mr. Kaiser. However, these allegations are based on the anonymous witness statement. And irrespective of the admissibility under Article 44 of the FIFA Code of Ethics, I submit that this witness statement shouldn't be given too much weight. And in order to substantiate this argument, I would now like to walk the tribunal through such witness statement. It begins on page 9 of the record, Exhibit 4, and it is the first page of Exhibit 4. If we look at the first page, members of the tribunal, we see, is the tribunal with me? We see on the first page that most of the information is redacted. So let's go to the next page, to page 2 of the witness statement. Again, members of the tribunal, most of the information is redacted. So the witness statement actually really starts on the 3rd page. And I would like to read from paragraph 13. I arrived at the restaurant at 8:30, half an hour ahead of schedule, to catch up with some emails over an aperitif. And then in the last line it reads, I could not identify these individuals as I was just facing their backs. Now, let's move to page 4 of the exhibit. Paragraph 19, the first line. My colleagues arrived soon after, so I stopped paying attention to the conversation. And then from paragraph 20, as the night went on, it became increasingly difficult to follow the conversation. So to recap, this is an individual who could not identify the people he's talking about. He was drinking alcohol, he was checking his emails, he was talking to his company, and he stated it became increasingly difficult to follow the conversation. Therefore, I submit, members of the tribunal, that this does not meet the threshold of comfortable satisfaction that Mr. Atom actually received any gifts from Mr. Kaiser. And lastly, I would like to address the TV revenue that the opposing counsel might raise as another advantage or alleged advantage that Mr. Atom received. Here, I would once again like to refer the tribunal to the witness statement on the last page, page 4, in paragraph 19. Here it is Mr. Atom who states, we really appreciate the offer of a match between our national teams in Tinyland. We'd be happy to talk to the broadcaster so that the revenues could be split at a 50-50 rate. This is Mr. Atom's proposal. And then Mr. Kaiser responded, and I would like to quote from the last line, you get to keep all the revenues. And then in paragraph 20, the witness states that it became increasingly difficult to follow the conversation. So there's no indication that Mr. Atom ever accepted the proposed waiver of revenues by Mr. Kaiser. His proposal was that it should be split at a 50-50 rate. Therefore, I would like to conclude this issue and state there was no advantage that Mr. Atom received from anyone on behalf of the Football Federation of Bigland. However, even if he did receive those advantages, there was no quid pro quo because there's no evidence tying the vote cast in favor of the World Cup to be hosted in Bigland to these alleged advantages. Here, I understand that the opposing counsel might raise the timing of the events as indicating such a link. However, members of the tribunal, this argument does not hold true. If we look at the timeline, then Mr. Atom went to Bigland on a fact-finding trip. He made up his mind, and subsequently he voted for Bigland because he deemed it to be the best suited country to host the World Cup, which is also why Bigland won the World Cup election. So there's nothing tying the vote to the advantages or the alleged advantages received by Mr. Atom, and consequently, there was no breach of Article 27 of the FIFA Code of Ethics. However, even if the tribunal is to find differently and assume that Mr. Atom breached Article 27, I would like to argue that the sanction of a 15-year ban and the fine of 50,000 Swiss francs is grossly disproportionate and must be reduced. This is based on two main arguments. First, because the circumstances of the case indicate so, and second, because the disproportionality also becomes evident when looking at CAS jurisprudence. I would like to refer the tribunal to the decision of Kwesi Nyantichi versus FIFA from 2018 with the case number 6072, which is contained in the appellant's legal authorities under AL15. In this case, the tribunal assessed mitigating factors for a breach of Article 27, Section 1, where a Ghanaian football official was being disciplined. And it held that an individual's service to the football community, as well as a lack of priors, shall be considered as mitigating circumstances. And if we look at the present case, Mr. Atom joined the Football Federation of Tinyland in 2009, and he became president in 2014, and he continued to serve in this position from there on. So he tremendously contributed to the well-being of the football community of Tinyland, and this shall be considered as a mitigating circumstance. Equally, there's nothing on the record indicating any previous impropriety on behalf of Mr. Atom or any proceedings initiated against him. So this should be considered as a further mitigating circumstance. And lastly, I would like to point out that Mr. Atom also paid back to Mr. Kaiser 20,000 Swiss francs, and therefore this shall be considered as a further mitigating factor in line with Article 9 of the FIFA Code of Ethics. Thus, the sanction of a 15-year ban, which effectively would mean a lifetime ban, and the fine of 50,000 Swiss francs is grossly disproportionate. And this is also in line with CAS jurisprudence, which brings me to my second argument on this issue. Here, I would like to refer the tribunal to the decision of Amos Adamu versus FIFA from 2011 with the case number 2426, which can be found in AL7. Here, Mr. Adamu met repeatedly with investigative journalists acting under a false name, and all those meetings that took 30 or 45 minutes respectively were recorded on audio and video. And Mr. Adamu knew what he was getting into, and he showed a clear intent to bribery. Yet, he was only sanctioned for a ban of 3 years and a fine of 10,000 Swiss francs. Equally, in the case of Ramon Maradiaga versus FIFA, under the case number 5886, a case that involved both match fixing and bribery, Mr. Maradiaga was only sanctioned to a ban of 2 years and a fine of 20,000 Swiss francs. Therefore, the sanction imposed is grossly disproportionate. And I would like to end on one last note, because the opposing counsel on the procedural issues already raised the integrity of FIFA. And I understand that the opposing counsel on the merits will again argue that the integrity of sports and the no tolerance of FIFA must be observed. However, members of the tribunal, these considerations aren't new. These considerations were made in the previous CAS awards as well. And they go to show that even in light of these considerations, the sanction is still grossly disproportionate, and Mr. Atte must not be a pawn that is being sacrificed to reach this goal. Thank you.
Thank you, counsel. Co-arbitrators, any questions at this moment or time, or do we hear first from counsel for respondents?
I do have a question, Mr. President.
Okay. Please go ahead.
Counsel for Appellant, you mentioned proportionality of the sanction. Which are the requirements of a proportionality according to CAS case law?
Mr. Arbitrator, are you asking about further circumstances that should be considered?
Okay, but is there any test according to CAS case law, any requirements that needs to be made for a measure to be proportionate?
What should be taken into account is the seriousness of the alleged offense. And then further, there can be mitigating factors that are to be taken into account, such as the service to the football community or a lack of priors. Now, if the Mr. Presiding Arbitrator is referring to Article 27, Section 3 of the FIFA Code of Ethics, we submit that Article 27, Section 3 is not applicable to the present case. And this is because...
I'm sorry to interrupt you, counsel. I was not thinking about Article 27. I was thinking about awards, CAS awards, dealing with the principle of proportionality and the requirements that needs to be met for any measure to be proportionate. So have you ever seen any decision from CAS panels dealing with proportionality in which these requirements are analyzed? And if yes, which are these requirements according to CAS case law?
I can only reiterate my previous submission, which is that under several CAS awards, such as the decision of Kwesi versus FIFA or Moon Young-jung versus FIFA, several circumstances were raised, and some of these circumstances apply in the present case as mitigating factors.
Thank you, counsel.
Mr. Vedovatti, maybe you can inform the counsel for Appellant on the test and ask him to comment on those requirements.
Yes, so there is a test for proportionality under CAS case, according to CAS case law, which, by the way, is the same test that it's applicable under Swiss law. So there are 3 requirements. So the measure needs to be apt for the goal. It must be necessary to achieve the goal. And the 3rd requirement is that the measure needs to be proportionate, stricter sense, in the sense that on a balance of interests, the sanction is justified. Okay, so this is the test according to CAS case law and according to Swiss law. So bearing in mind that this is the test, which is your position in this case? Do you think that this proportionality test, the requirements are met or not met, and why?
Mr. Arbitrator, I would argue that the requirements would be met with an even lower sanction. First, you referred to that the sanction must be apt to reach the goal, and I would argue that there's no need to sanction Mr. Atten with a 15 years ban. Because even a lower sanction would already make it increasingly difficult for him to go back to the football community of Thailand and start working there again, or another function as a football official. And regarding the necessity to reach such goal, I would further argue that a ban of 15 years would even go beyond the goal, because Mr. Atom is 40 now, so he would come back at being 55, and it would be almost impossible for him to start working again in a football federation of Thailand. And under the last requirement that I understand as a broader test of proportionality, I would like to refer back to the questions of the mitigating circumstances and submit that such mitigating circumstances are in place in the case at hand.
Okay, thank you. Mr. Koolaard, would you have any question or no follow-up questions?
No, no questions for the time being.
Okay, all right. Then we give the floor to counsels for respondents.
Thank you. Good afternoon, esteemed panelists. Once again, my name is Sydnie Hornback, and along with my co-counsel, we represent the respondent, FIFA. We are here today to not only protect the integrity of this sport, but on a larger scale, the global connections. Sports represents more than just the game. It represents countries' culture, countries' politics, and if there's a question about the integrity, we risk the loss of other countries' participation. This panel has a responsibility to uphold the integrity of this sport and not destroy what FIFA has created. Esteemed panelists, I will address 2 points. The first, Mr. Adam did violate Article 27 of the FIFA Code of Ethics. And the second, the sanctions imposed because of this violation are reasonable and proportionate. To my first point, Mr. Adam violated Article 27 of the FIFA Code of Ethics. As opposing counsel states the elements required, they are actually all met here to show that Mr. Adam has committed an act of bribery. The first requirement, as opposing counsel correctly stated, the person must be bound by the FIFA Code of Ethics. And here this element is not in dispute because Mr. Adam is the president and therefore bound by the FIFA Code of Ethics. Requirement 2 is that the person must have accepted. Here, Mr. Adam accepted. He accepted a variety of things offered by Mr. Kaiser, who is the president of the Football Federation of Bigland. Mr. Adam accepted 3 essential things. He accepted the promise of hosting a free match between Tinyland and Bigland, receiving all of the revenue. And he also accepted a luxurious trip to Bigland with all expenses paid. And while Mr. Adam was on that trip, he accepted incentive after incentive in order to get the vote for the World Cup. Requirement 3 is showing that the acceptances were for a personal or undue advantage. And here, all 3 things Mr. Adam accepted were for an advantage. Starting with the match, Mr. Adam agreed that if Bigland won the election for the World Cup, Bigland would organize a match in Tinyland without requiring any of the revenue. The acceptance of this match was for a personal and undue advantage. As opposing counsel states, the appellant tried to provide a 50-50 split. However, there is also no indication that he denied this. Again, Mr. Adam can't control what Mr. Kaiser offers, but he can't control what he accepts or denies. And essentially, the fact that this match never took place is irrelevant because as found in Exhibit 6, paragraph 52, the rule is breached when the unlawful agreement takes place and not when the improper advantage is eventually received. Secondly, the appellant's wife is a shareholder of the football broadcaster in Tinyland, and such broadcaster usually has to pay a portion of its revenue to Bigland, which is found in the record, page 2, paragraph 1, which here that would not happen because it was offered for free. As laid out in Article 27, paragraph 1 of the FIFA Code of Ethics, the advantage can be for a third party by or close to the official. So here the appellant's wife is a third party and clearly receiving an advantage of not having to pay any revenue at her broadcasting company. And additionally, it is not, sorry, arbitrator, was there a question?
Yes, counsel, I'm sorry to interrupt you there. In terms of this position on the wife of Mr. Atom having a benefit, you're saying that there is a benefit there because they will not have to pay Bigland any share of the revenues of broadcasting that game. That's correct?
Yes, that is correct. Yes.
But, and this is the difficulty I have on this specific point, in that case, would they not have to pay 100% to Tinyland? If you say that they were to receive 100% of the revenues from that game?
Tinyland would receive 100% of the revenues for the game. However, as found on page 2, paragraph 1 of the record, it states that usually the broadcasting company would have to pay a portion of its revenue to Bigland. And here that's not happening.
Well, that's clear for me. But here's my question is, if they're not paying to Bigland, they're paying everything to Tinyland, what's the undue advantage for the broadcasting company? Because at the end of the day, they're paying either 50-50 or 100% to one, assuming that is what was discussed and agreed. So what is the advantage there for the broadcasting company, which the wife is a minority shareholder?
The advantage for the broadcasting company is that she would not have to provide any of the revenues to Bigland. So Tinyland is receiving all of the revenues, and usually common practice is that the football broadcasting company would have to pay a portion. And so she's receiving an advantage because she doesn't have to pay that portion to Bigland.
But she would have to pay it to Tinyland.
Correct, but she would not have to pay it to Bigland, and she works in Tinyland at the broadcasting company. However, she would usually have to provide money to Bigland as well, and in this case, she would not do so.
Okay, thank you, guys. I think we're turning circles here. Please continue.
Okay. Additionally, in regards to the match, it is not uncommon practice for Football Federation of Bigland to waive any compensation for matches. And because of all these reasons, the match accepted by Mr. Adam was for a clear advantage and was reliant on Bigland winning the election to host the World Cup. Moving to the second advantage accepted by Mr. Adam, the all-inclusive luxurious trip. The trip included free flights and free accommodation. This is clearly a personal advantage because Mr. Adam was able to travel and stay in Bigland for free. Article 27, paragraph 2 states that persons bound by this code shall refrain from any activity or behavior that might give rise to the appearance or suspicion of a breach of this article. Opposing counsel argues that Mr. Adam didn't know that this was bribery. However, it's pretty clear that any of these offers and incentives would give rise to suspicion, especially with the World Cup voting being right around the corner. The circumstantial evidence in this case is especially relevant because we are dealing with bribery and corruption. Of course, the parties involved in bribery and corruption will take efforts to conceal their wrongdoings. So opposing counsel essentially points out the agenda of this trip, which is actually very important to look at here. They even admitted that the trip was to see Bigland to decide for the World Cup election. Mr. Kaiser took Mr. Adam to visit the tourist locations of Bigland. And this is not an everyday business trip agenda, which Mr. Kaiser proposed in the email to Mr. Adam, and should have risen suspicion in Mr. Adam's eyes. Additionally, it is one thing to offer hospitality when inviting colleagues to visit your country, but it is another to consciously offer incentive after incentive, which includes Adam was given free massages at his hotel. He was also able to have anything delivered to his room at any time under Mr. Kaiser's account. Adam attended a luxurious club where, I quote, he never had to even touch his wallet in Exhibit 4, paragraph 17. And also he received brand new watches. Taking the circumstances as a whole, Mr. Kaiser was clearly offering incentive after incentive, and Mr. Adam was well aware what was happening. Mr. Adam can't control Mr. Kaiser's offers, however, he can control his own actions. All 4 requirements are met, and Mr. Adam thereby breached Article 27 of the FIFA Code of Ethics. To my second point, the sanctions imposed for this violation are proportionate to the offense at hand. Again, as opposing counsel stated, the 2 sanctions imposed here was a ban on taking part in any football-related activity for 15 years and a fine of 50,000 Swiss franc. These sanctions are essential in order to deter individuals from engaging in unethical behavior in the future. As opposing counsel points out, the time Mr. Adam has spent in his position is clearly, he knows what the FIFA Code of Ethics is, and these acts should have risen suspicion to him. So the fact that he has held this position for a period of time goes against his favor. And in our legal authority number 12, which is Vernon versus FIFA, an important message for all members of the sporting community, the panel states that a finding of bribery presumptuously attracts the maximum sentence, which would be a life ban. And here, Mr. Adam didn't even receive a life ban, which is already lenient in relation to a high violation of bribery. And also pursuant to Article 27, paragraph 3, it states that the sanctions shall be increased accordingly when the person holds a high position in football, as well as in relation to relevance and the amount of advantages received. So here we see that Mr. Adam is the president of the Football Federation of Thailand, therefore holding one of the highest positions in football as president. And Mr. Adam received multiple advantages and not just one. The test for proportionality according to CAS law is met because the necessity to achieve this goal is essential to deter individuals from engaging in this kind of behavior in the future. Bribery is a very high violation, and the sanctions imposed must be proportionate to that violation. Violations as such affect the very core of sports, and if officials who violate the ethics code remain within the sports structure, this will cause irreparable damage. So for these foregoing reasons, Mr. Adam has violated Article 27 of the FIFA Code of Ethics, and the sanctions imposed are proportionate and reasonable. Thank you.
Thank you, counsel. Do my colleagues have any questions, or should we first hear rebuttal and then have some questions from our side? Opinion from my colleagues?
I have some questions, but maybe first the rebuttals, and then we can address
Yes.
it afterwards.
Okay, good. Please, counsel for Appellant.
Honorable Tribunal.
We are running short of time, so I would ask you to be concise and quick.
Honorable Tribunal, we would like to restate that we are talking about the wording used by Mr. Vach. However, opposing counsel is talking about his stance. As we read the initiative in the Sydnie case, a person, specific an arbitrator, is free to express their opinion online. However, the word and the circumstances must be taken into account. Thank you.
Okay, any further comments from counsel for Respondent?
Yes, esteemed panelists, thank you. Once again,
Please also be quick. Thank you.
Thank you. As opposing counsel very clearly stated, the LinkedIn comment is Mr. Vach's only comment as of now, and it does not rise to such a level as to challenge Mr. Vach's impartiality. We are before the CAS on the issue of bribery, not vaccinations. And lastly, opposing counsel argued that the telegram evidence infringes on Mr. Adams' right to be heard, but did not challenge the accuracy of the message. This is because they are real and they should be used to hold this official accountable.
Okay.
Thank you.
Counsel, we're asking the rebuttal. This goes for both counsel. We're actually asking a rebuttal to what was mentioned in terms of the breach and the sanction, not yet final closing remark, but that's fine. We'll get to that. We've heard your final closing remarks. Maybe we'll have to repeat them later on, or maybe you want to add something, but let's first hear the questions from Mr. Koolaard then.
Thank you very much, Mr. President. I would like to hear from respondents particularly what impact has the 20,000 reimbursement that Mr. Atom made? Is that to be regarded as a mitigating factor, or should we interpret that differently?
Yes, of course. The repayment here by Mr. Adam, if anything, the repayment shows that Mr. Adam is guilty, because if it wasn't a bribe, why would he make a repayment? He was not involved in the criminal proceedings, so why should that decision matter if he actually did not violate anything? So here, we would not be here today if Mr. Adam was saying that he was guilty and he did violate this breach. So we should not take the repayment as a mitigating factor because he has not expressed any remorse for the situation. And showing remorse or confession would be a mitigating factor. However, we wouldn't be here today if Mr. Adam was saying that he was in violation and he would accept this sanction.
Thank you very much. Appellant?
Mr. Arbitrator, I can only reiterate our previous argument regarding Article 9 of the FIFA Code of Ethics, that such reimbursement shall be considered as a mitigating factor. And in addition, I would like to refer to the decision of Quesinianteci versus FIFA, in which the panel used the amount of advantages received as a starting point in calculating the fine. Now, if we look at the fact that it's not even sure how much Mr. Atom received, but he still reimbursed 20,000 Swiss francs, this goes to show that a fine of 50,000 Swiss francs is disproportionate. Thank you.
Thank you very much. There's 3 advantages that Mr. Atom allegedly received. The trip, the watches, and the TV rights deal. If you look at those 3 in terms of value, it seems clear that the TV rights deal is much bigger than the other 2. Should we conclude that the trip was an undue advantage, as well as the watches, but the TV rights deal, there's not enough evidence? How does that impact on the proportionality of the sanctions to be imposed? First respondents, please.
Of course, whichever acceptance that this panel decides to take into consideration when doing the sanction. At the end of the day, every single acceptance offer that was accepted by Mr. Adam is a violation of bribery. And again, as stated in the Vernon versus FIFA case, violations of bribery must be taken very seriously, as well as looking at the mitigating factors in Article 9, which do show that Mr. Adam has held the position for quite a while. So he knows the standard for the FIFA Code of Ethics, and individuals who hold such a standard, no matter how many offers have been accepted, it's still a violation of bribery. And if we don't punish a violation of bribery reasonably and proportionate to the offense, officials might think that they can get away with it in the future if it's just one acceptance or 2 acceptances. So therefore, no matter which acceptance this panel decides to take into consideration, it is still a violation of bribery.
Thank you. Appellants?
I would like to answer your question, Mr. Arbitrator, and refer to the fact that assuming that the TV revenue is an advantage, then first, Mr. Atom or his wife never received such advantage because this match never took place. Secondly, it is not all the revenue that would go to Mr. Atom or his wife, because she only owes 12% in the shares. And lastly, there's nothing on the record indicating how much the value of that match would be, even though I understand the Tribunal's assumption that it might be a considerable value. Thank you.
Okay, thank you very much. Is there time for a last question, Mr. President, or will I leave it at that?
No, please proceed.
I have a little bit of a theoretical question. There's lots of cost jurisprudence saying that an arbitral tribunal, cost in appeals instances, should pay deference to the decision in terms of proportionality of the first instance tribunal. There's also jurisprudence saying that cost decides de novo. So we decide the case completely fresh. We are not an administrative court reviewing the correctness of the first instance decision. How do you see that? Both parties, please. First, the appellant.
Mr. Arbitrator, of course, CAS has a de novo power under Article 57 of the CAS rules, and it is not bound by any previous CAS jurisprudence. So there's no binding precedent in the present case. However, we would like you to consider this as in order to assert a certain standard or a certain legal standard, and what is proportionate under the lex sportiva, and also in light of the considerations of comity and legal certainty, just to take this case law in consideration as a guidance.
Thank you. Respondents?
Yes, our position is that CAS is not a court of precedent, so therefore each situation and circumstances are weighed on a case-by-case basis as found in Article 57. So taking into consideration all the possible standards that could possibly be applied and looking at each situation and each acceptance that was offered to Mr. Adam, it is still a clear case of bribery, no matter if we focus on the precedent or the legal standard or review de novo. At the end of the day, we still have a case of bribery here, and there is still a violation.
So you're saying that we can decide de novo and that we do not necessarily need to pay deference to the first instance decision?
Yes.
Thank you very much.
Okay, it's an interesting remark from counsel. Mr. Vedovatti, do you have any questions?
I don't have any question, Mr. President. Thank you.
Okay, let's see. I actually have one question for respondent as well. Do you understand correct? For what concerns the offered match in the revenue share and the alleged undue advantage, do you understand correctly that FIFA considers that you consider that the undue advantage was having accepted, assuming that it was accepted? Having 100% of the revenues, or is there something more of an undue advantage as to that specific point?
There is also another factor here that shows that it's an undue advantage because as found in the procedural order, page 8, paragraph 21, the Football Federation of Bigland is one of the biggest national football federations in the world. So making it a very beneficial match for Tinyland to go up against such a popular football federation. So including the revenue that would be provided to appellant's wife, as well as the match as a whole, would be advantages.
Okay, thank you for that clarification.
Thank you.
Okay, no further questions from my side. I don't know if Appellant wants to react to that specific last comment from respondents.
Mr. Arbitrator, I understand that we are short on time, but I would like to make a short rebuttal if that is possible.
Yes, very quickly, please.
Certainly. I would like to address the TV revenue that has been brought up again and again in these hearings. Counsel stated that there's nothing indicating that Mr. Adam accepted or denied the proposed 100% to be received by Tinyland. But I can only reiterate that the burden of proof is on respondent to show that Mr. Adam accepted, and it is not on the appellant to show that they denied the revenue. And also, I would like to make one brief remark regarding the statement that the TV revenue was reliant on Bigland to host the World Cup, because there's nothing in the case file that indicates this. The only thing that indicates this is the assessment of facts in the FIFA appeal decision, but we are disputing that very decision, and therefore it should not be taken into account. Thank you.
Counsel. All right, that leads us to the end of the hearing. I understand closing statements were made before we were asking our questions, and we gave you the opportunity for a rebuttal. Maybe very quickly, 20 seconds or 30 seconds if you want to add anything specific in your final closing statements. Appellant and respondent, any further comments?
No, thank you. On behalf of the respondents, we rest our case. Thank you.
Okay.
No, thank you, Honorable Tribunal. It has been an honor to plead in front of you.
Okay, thank you very much. Well, that brings us to the end of the hearing. I have one final question for the counsel of the parties: whether your right to be respected, whether your right to be heard has been respected in the case at hand.
Yes, Honorable Tribunal.
Okay, thank you. And for respondents?
Yes, esteemed panelists, thank you.
Okay, thank you very much, counsels. We'll take the case into deliberation now, and we will render an award in due course. Thank you very much, and have a nice day.